So thank you everyone for coming to this the virtual panel, which is on law and methodology, which is something that I'm quite interested in. I'll just introduce myself a little bit too. I'm Sarah Ross, and I'm located in Halifax, Canada. It's kind of an interesting opportunity. We're all coming around here from all over the world. So I'm at the Schulich School of Law at Dalhousie. So I'm interested in law and methodology because I do a lot of socio-legal work as part of my comparative law scholarship as well. And so I draw a lot on anthropology and things like that in my methods. So very excited to be chairing this panel. So how I thought we would proceed is we've got about an hour and 45 minutes, and I noticed that the next panel starts right after. So I thought maybe we would end just, 5 minutes or so early, so that we can take a little break in between panels and, get some tea, coffee, or what have you in between. So with that, so that's a little bit about me and our panel, and we've got 3 panelists today. So, or 3 papers rather, one with 2 authors. I'm not sure if both authors are here, but what I thought we would do is if everyone spoke for around, no longer than 20 minutes or so, we're a bit more flexible with time with just the 3 papers. And then that way we can have a nice chunk of time afterwards for questions and comments and engagement with everyone's papers. So it's a little bit difficult. Usually, you've got the little, I made this for when there's 2 minutes left, but I think that's kind of, doesn't really work. I know doing these Zoom conferences, you're kind of into your presentation, maybe the screen is being shared, so you don't necessarily see. So I'll hopefully just try and govern yourselves in terms of time. Like I said, no longer than 20 minutes, let's aim for that. And I think that's about it. And if you can just give a little very brief introduction, who you are, what generally you're working on, whether you're a PhD student, a younger comparativist in another way, what university you're at, just a little bit so that we have a sense of everyone in our virtual room today. So without further ado, and let's just proceed in the order that we have in the schedule. So that way if people are popping in at different times, we'll kind of have a sense of where we are in the program. So our first paper is, I see Vanessa's here. So go ahead whenever you're ready. Oh, and feel free to share your screen or what have you through PowerPoints, but also not necessary, of course, if you don't.
Yes, I would like to share my screen, but I need you to enable me to share my screen.
Sure thing. Here, let me see. I think, Antonia, are you there? Do you know how I can do that?
I think you have to make me a host.
Okay.
I don't know how to do that.
Yes, I think you should make the host, each panelist the host in order to.
Okay. So let's do that. There we go. That should work. Is it good? You're seeing it?
Yes.
Okay, perfect.
Thank you.
No problem.
Just bear with me 1 second. Okay, so thank you for the introduction. I would like to thank the American Society of Comparative Law, the Younger Comparativist Committee, and the organizers at UCLA. It's a great pleasure to be part of this panel today. And I will start by pointing out my motivation in writing up this piece. I've been working in the field of comparative law since I was in Italy. A JD from Italy, from the University of Genova. And my approach to comparative law was theoretical, descriptive, sometimes normative. I was working in the field of trust law, but never left the field of law. When I started the doctorate program at the University of Illinois, I was impressed by the emphasis that was given to interdisciplinarity. And I realized that there is an entire universe of methodologies that are vastly applied in social sciences, and some of them are also applied in law, but they are scarcely advanced in the field of comparative law. So I decided to explain how the comparative field will benefit from applying empirical methods. This is a quick overview of my presentation. I will start with the need for empirical studies in comparative law, the scope of the empirical research, the type of methodologies in the legal field, some examples, of course, the one precise example of regression analysis, some limitations and conclusions. So this first point is, why does a legal scholar need comparative studies and need empirical studies? Excuse me. My immediate response would be because of the sophistication in the results, and I will unwrap this a bit. More than 20 years ago, the only quantitative methods applied in law were inferential statistic, which is a technique borrowed from econometrics. It points to mostly used in the corporate and financial studies, and this is a mathematical approach, mathematical analysis that is congenial to quantitative research, pointing out to a numerical result, but leaves inconclusive other questions that pertain to law, such as policy. The advantage of empirical methods in law is that its reverse engineering thought process produces sophisticated results. It challenges assumptions rather than merely reverting to speculation and, in some cases, pure intuition. Observation, of course, is a foundational part of empirical studies because it follows the scientific method. That means that we need to observe data from the real world and draw inferences about the law with that evidence. The results of combined empirical methodologies are a good source for understanding the real world and helping us in theorizing about the law. So this led us to what kind of questions we can answer with empirical research. Of course, the type of questions are limited. We can answer composition questions such as what are the legal forms in a specific legal system, descriptive and causal questions. However, pure quantitative methods would not be in help when answering non-causal questions such as the understanding of a legal system, categorizations of legal rules, and even harmonization. Where those studies place? So empirical comparative studies emerge as a subsection of empirical legal studies. Its main feature resides in the use of cross-country data. And I refer here to data as formal materials, such as judgments, but also other type of actors, judges and jurors, and so on. There is a recent data science development that has prompted the legal audience to an accelerated application of interdisciplinary empirical tools. At the same time, requires that this solution be handled by a jurist, someone who can make a harmonious interpretation between data and theory. These studies are mainly descriptive, and the relevance resides in establishing a neutral standard for comparison. The approach to comparative law, the functionalist approach, reflects this view of interdisciplinarity. We compare institutions, we compare legal systems to find them functionally equivalent. We must uncover those equivalences with the standards from outside the field of law. The use of empirical research in comparative law is of great importance, not only support the comparison between legal problems, but also because the comparativist does not need to start from scratch when doing this type of research. And I will provide some examples of how can we do that. The studies already done in other fields of legal systems concern us to put the comparativist halfway to the final goal. It's not necessary to do empirical research into areas, but to integrate the data of the original study and replicate it. So having these premises in mind, I will briefly provide an account of different types of empirical work in multiple areas of the law and how can they be connected to comparative law. And I will start with a methodology that has been ignored with few exceptions, by comparativists. And I really won't delve that much on this point. But I would like to highlight that legal scholars were initially skeptical about rational choice theory due to its inability to mirror concrete scenarios, especially regarding the normative law in economics and the efficiency standard applied, which appear unsound for most comparativists. Excuse me. Those critics were unsuccessful since there wasn't any way really to refute these results with a comparable empirical methodology. This was true until obviously behavioralists developed these cognitive studies and lab experiments in order to understand how people make choices. And I believe that comparative law can make useful additions in the contextualization of those choices and in the influence of society in determining the surrounding circumstances of those choices. So here are the existing studies not done with the comparativist mindset, whose results anyway allow us to compare. And one of them is randomized controlled trials, or the so-called gold standard of empirical research. This kind of experiments randomly assign cases, people, judges, to or units to different conditions. After careful observation, the study will tell us whether the experimental group, the one receiving treatment, reacts differently from the control group, the one that is not receiving treatment, and namely controlling for that added variable in the opposing group. After measuring and comparing both randomly assigned groups, the results would highlight the difference between them, whether they achieve the desired outcome or there is an alternative explanation. And this application has been useful to understand how decision makers, judges, and jurors resolve issues according to risk assessment, jury instruction, and so forth. Another example of studies done in the legal field, not with the comparativist mindset, are the studies in law and psychology. These experiments provide some interesting reflections regarding tort liability and how people decide compensation, tort compensation, uh, showing how fact finders are commonly affected by heuristics. People tend to be in discomfort when dealing with dullness in situations. And the results of these experiments were consistent with real world observations. And this is a study of 10,000 negligence lawsuits that proposed to test comparative negligence in its two variations, partial and pure and partial or modified. The results offer a twisted mechanism in which fact finders awarded plaintiff recovery, depending on the type of standard assigned. So sometimes granting recovery that was otherwise barred, based sometimes on moral judgment, such as fairness, and especially the studies show that there are many cases of victims overcompensation with partial or modified comparative negligence. Comparativists can use law and psychology to bring out these issues with those rules and standards in different legal systems. When the fact finder is a jury, as opposed when in systems where the judge is acting at the same time as the fact finder and decision maker. If we consider that all human beings are affected by heuristic, these studies can show overcompensation in other legal systems. Network analysis is another technique used to shed light in small-scale interactions between individuals and the influence of their information as well as community development. Those studies are grounded on sociometry to identify sociological relationship and to understand the relationships between groups, between non-primary groups in a given social structure. And here the central idea of network analysis is that those to whom our relationship is weak, that are placed in the weak ties, evolve in different contexts and thus have access to different, more varied, more useful information, qualitatively more valuable information. One of its applications has been in the study of agencies and their network interactions in advancing enforcement. And this is a study of SEC gratitude acknowledgements in press releases and the types of cooperation in investigations. The study confirmed what we all knew in the corporate sector, that SEC collaborations with common with formal institutions and self-regulatory organizations, but uncovered the prominent role of US postal inspectors, This was, of course, an unexpected actor. And the benefits are that foreigners will favorably benefit from by implementing its task force, identifying and uncovering conducts not otherwise discoverable. And we can expand this analysis to whistleblower regulation by comparing network analysis between agencies in different systems and the actors in different networks. Here's another example of network analysis in comparative law, and that try to address the damages, quote unquote damages, of the legal origins studies employing comparative methodology and taxonomy through a case-based approach. The point that I would like to highlight is that here comparative law inform a question in corporate law. So this empirical study was mainly descriptive, finding no global convergence of corporate laws, despite in the numerous transplants that were the numerous legal transplants around the world, copying basically the US corporate laws, but it was at the same time not only descriptive, but also normative in terms of future European harmonization. And this is a good example of combined methods and the future of comparative law. So how do we do this? Here are the steps of empirical research. First of all, as we all know, we have to identify a topic. For our purpose, this is a cross-country area that embraces and solves questions of law. We have to review and find theories that are useful in the research design, invoking the one that tend to produce observable implications. And after that, we will be able to elaborate a plan on how to observe those implications. Then it follows the research question or hypothesis. We will theorize or speculate about its answer. There is not a single direction in which the research question will point. We can update a previous work that needs to be updated because we have new data, we have new technology. It can also address conflicting responses. The hypothesis also serves the purpose of testing predictions or outcomes that we expect to see in each situation. If we think in terms of an equation, we will have independent variables or outcomes and dependent variables that are the content of the outcome we will try to explain in our research. Finally, from the identification of those variables follows an important step, which is measurement, comparing the object of a study with a standard. And here I propose a brief example of a common technique, which is regression analysis. It's a technique borrowed from economists, and it's used in many fields of law. Its language has been part of our daily basis parlance. We tend to say two things are correlated to make somewhat a comparison, although correlation involves more than that. And this is an unpublished preliminary study that I conducted regarding initial coin offerings. Initial coin offerings are vehicles for funding startups that use smart contracts in blockchain. For those of you who do not know what is blockchain, it's an unregulated virtual world. And one way for me to understand this phenomenon is by comparing the virtual world with the real world. So this was my hypothesis, whether know your customer practices affect the success of the initial coin offering process and could lead to refraining investment and innovation. So the first thing to say here is just to provide a definition of know your customers. Know your customers are those due diligence procedures applied to financial institutions to extract information from buyers. It's basically something that financial institutions need to follow according to anti-money laundering provisions. And there was conflicting information from several studies in the corporate sector regarding how these practices, the know your customer practices, created a negative effect on ICOs, mainly the cost of doing business. Following the studies on initial public offerings, which are a regulated mechanism for having access to public capital. And so I started to making the research design. I started to look for the components of a successful ICO. On the one hand, I tried to define ICO success, and I define it as the minimum amount of money raised by to finance their startups And then I start defining also the variables. So one was KYC, the other was the number of tokens for sale, the exchange, which is an intermediary that is used to buy tokens, and several other components. At the end, this will be my equation. I will see on one hand the outcome of independent variable, which is what I want to see in every successful ICO, and then the following variables that I expect to see according to theory in any successful ICO. It is useful to make some descriptive statistics to summarize the data. To have the median, the mode, the mean, some percentages is fine, although it's not enough. So only the regression analysis can show the strength of the relationship between categorical variables. And here are the results of the logic regression, which shows the odds of the occurrence of the event, which is the probability of seeing these variables in any successful ICO. And as you can see, the highlighted areas refer to the variables that are correlated with the ICO success. And I mean here by correlation, the ones that are statistically significant, or probability is determined by an arbitrary measure equal or higher to 5%. As a result, we can reject the null hypothesis of no relationship between these practices and a successfully funded ICO, namely that a true relationship exists between them. And the regression analysis also showed two other relationships, one positive and one negative. The one that was positive was the use of this intermediary, and the negative was tax regulation. One important thing was the assumption of the relevance of the country. It was confirmed, since there is no correlation. Thus, the alleged country of origin of the startups played no role when launching an LCO. It reinforces in some way the functional equivalence of the macro areas that I previously defined for comparison. So on the one hand, the real world, and the other hand, the virtual world. The implications from these results are that in this decentralized virtual world where there are no reputational renters, there are no intermediaries, the only way to signal market integrity and transparency by these startups was by exacting information from potential asset holders, and basically that these due diligence procedures, as opposed to what the majority of the legal theories on IPOs were saying, does not negatively affect the capital structure of crypto assets. So what are the limitations on empirical research? There is a profound difference between law and other areas. And the main difference, besides that juries are asked sometimes to solve problems contingent to time, and empirical studies do not provide a definite answer, but are cumulative on their work. It's hard work or grabby work outside of the realm of law and potentially value-free. These methodologies are powerful tools in providing answers to specific legal questions, but they are not helpful in answering the whole scenario of legal questions. Writing surveys demand a detail-oriented work in framing questions to avoid influencing participants, and those questions must be standardized. Comparative law has obviously an added hurdle of having multilingual cross-country participants, which carries also standardization of questions and language. It is also a good habit not to draw immediately inferences, because those results can have other explanations not initially envisioned. This led us to a caveat regarding empirical causative studies, which fundamental problem is certainty. Those studies require information from the real world. So legislation is enacted or not, but we cannot reverse those facts. In fact, empirical analysis is framed in terms of association, relationship, or correlation. We are in a probabilistic, non-deterministic world. And also, transparency is necessary. We need replication. However, this replication sometimes is considered less prestigious to a legal scholars that prefer theory or models, and have also a great cost towards scholars that do not have prior statistical training. These are long and expensive projects. In some areas, they need funding. And we have found many open data sets and many other tools that can help empirical work, but they can reduce the cost of doing research, but has not diminished the cost of doing empirical comparative research. In many countries, databases are protected by copyright, and this can certainly undermine empirical studies. So to conclude, the message of this presentation is that these empirical methods provide evidence capable to correct a false understanding of a substantive area of the law with extrinsic methodology. The most difficult part is to reconcile those empirical methods with the comparative approach, trying to distinguish the empirical questions that use cross-country data and empirical questions in comparative law. I think that it's necessary to build some sort of base knowledge regarding at least from a consumer perspective, empirical research, to be able to engage in the empirical debate and to collect also greater interest in comparative law. To conclude, interdisciplinarity is a two-way path. While other disciplines might help in answering comparative law questions, comparative law might also be in support of other disciplines, informing questions from other social sciences. And with this, I stop myself. Thank you.
Thanks very much. Okay, so now what we have to do for the next presentation, if you can transfer the host back to me, then we have one of our co-presenters who I think is in the waiting room to get in. Let's see. Yeah, so Vanessa, if you can transfer the host back to me.
Yeah, I'm looking.
Okay.
So, where should I?
So if you go under participants.
Okay.
Click on participants, and then you'll see if you hover over my name, then you can make host.
Okay.
Okay, there we go. And then got it. Okay. Just letting everyone in. They're coming in. Okay, well, perfect. Thanks. So thank you very much, Vanessa, and welcome. Oh, there goes my voice. Welcome to our new attendees. So now we're going to move on to our second paper today, which I believe has two presenters. And Roween, is your co-presenter here now?
Yes, he's in now.
Okay.
Hi, Samuel.
Okay.
Yes.
Perfect. So now, which one of you do you have a screen that you want to share?
I have a screen to share.
You do. Okay. So what I will do is I'll transfer the host over to you, and then you can share your screen. And then as soon as you're done, transfer it back to me, and then we'll go on to our third presentation. So here we go.
Okay.
Oops, hang on.
Wait.
Okay, so
All right. You should be good to go.
Okay. Wait. Can you see it?
The screen is coming.
Yes.
Yes, it's coming. Yeah. Thank you.
Perfect. Okay. Here we go.
Okay, so I'm going to start our presentation. Well, okay. So this is our PowerPoint. Well, our today presentation is concerned with the implementation of Hans Kelsen's model of constitutional review into Southeast Asian countries, Thailand and Indonesia. Well, in these countries, the implementation of Hans Kelsen's constitutional review, the model of constitutional review has to, struggle against the prevailing national ideologies, which, underlies the importance of strong leadership and national security, national unity, known as Thainess and Panchasila, respectively. So we will primarily explain the key features of Hans Kelsen's model of constitutional review before explaining the implementation in Thailand and Indonesia, respectively. So let's begin with the key features of Hans Kelsen's model. Well, Hans Kelsen, an Austrian jurist, believed that the politics of compromise associated with liberal parliamentary democracy is a key to which can help foster peace in a pluralistic society. So he, entrusts upon the constitutional court to, to protect this idea. But the problem is that, in Thailand and Indonesia, the incumbent elites, have turned the constitutional court into a weapon to subvert, liberal parliamentary democracy itself. So I'm going to present the situation in Thailand, and then my friend Satrio will talk about what happens in Indonesia. So please go to the next slide, please. Next slide, yeah. So as I'm sure that perhaps many of you already know about the current situation in Thailand. Even today, we have a protest in Bangkok. The current protest reflects the contemporary conflict between the two factions in Thailand. Well, 21st century Thailand has experienced, I would say, the intractable conflict and political clashes between two factions, the pro-democracy supporters on the one hand and the loyalist conservative elites on the other. Well, Thailand is now, I would say Thailand has been ruled by the loyalist conservative elites for many, many years. And, these elites, normally emphasizes the primacy of national unity and strong leadership over the protection of human rights. And this idea of national unity and strong leadership is, I would say it is based upon the national ideology called Thainess. Well, Thainess emphasizes, the unity of the nation embodied by the righteous Buddhist king. And of course, in the past, the Thai elites normally impose a military coup, impose many military coups, to protect this idea. But in reality, they just invoke the idea of the protection of Thainess just in order to justify their political to preserve their political hegemony. But at present, the imposition of military coups has become outdated. So the elites have to find an alternative means in order to to preserve their hegemonic political status. So they decide they decide to turn the Thai Constitutional Court into their ally. So that is why if you surf on the internet, you can see a lot of articles that their authors write something about the politicization of the Thai Constitutional Court. This is what has happened in my country for a decade. Well, as we can see, at present, many Thai Constitutional Court justice have been appointed by the royalist conservatives. So that is why the decisions made by the court inclined to inclined to be, I would say, pro conservative. Well, as I show in the next slide, please go to the next slide. Yes, as I show in this PowerPoint, well, the Thai Constitutional Court has played a vital role in, I would say, replacing the development of parliamentary democracy in Thailand, especially since 2008. Well, for instance, in 2013 and between 2013 and 2014, there was the mobilization of the loyalist conservative supporters in order to overthrow the then liberal government. But the problem is that the Constitutional Court, rather than protecting the government, it justified the mobilization of the civic networks against liberal democracy. And despite the acts of vandalism, the court decided such mobilization constitutional. This is quite absurd, but it had happened in the past. And in 2013, the Thai Constitutional Court also void the attempt by the anti-junta members of parliament to amend the provisions of the 2007 constitution establishing the system of the appointed Senate. Well, in Thailand, the appointed Senate I would say complies mostly pro-junta activists, and this institute functioned mainly to appoint members of the watchdog agencies, including the Constitutional Court Justice in Thailand. So this means that the appointed Senate in Thailand play a vital role in preserving and ensuring the political hegemony of the royalist conservative, and rather than attempting to abolish this institute, the court says that we need to the Thai constitution has to preserve this thing in order to ensure the unity of the nation. In fact, as I said, it's a kind of the attempt to to preserve the political hegemonic status of the loyalist conservatives. So now let's see what has happened in Asia. I will pass my microphone to my friend Satriel. Thank you.
Okay, thank you, Rawit. I will explain more about Indonesia, the Thailand network. Okay, so first I need to explain about the history of Indonesia itself for presenting my argument, because before 1998, Indonesia actually is always have ruled by authoritarian regimes. The first is Suharto New Order regime, and then the Sukarno guided democratic regime. And what interesting about these two regimes is they preserve their autocratic regimes with using the state ideology of Pancasila that contained in the preamble of the Indonesian constitutions to justify their autocratic ruler. And the Pancasila itself is actually ideology that consists of 5 abstract principles: belief in God, humanitarianism, unity, democracy, and social justice. And these two authoritarian regime built an impression and indoctrinate to society that this ideology is the legitimate basis for the Indonesian state to build. And since they rule for very long time, I think since 1945 until 1998, this authoritarian regime. So it makes sense that this ideology have a deep root in Indonesian society. And however, in 1998, my country decided to transition to democracy. It was called the reformasi process, and the process to transition to democracy itself come with what Professor Paul Blocker say as legal revolutions, because it's not happened with the bloody revolutions or something like that, but it's happened with revolution that come with the constitutional amendment process to the Indonesian 1945 constitutions. And one of the achievement of the transition itself is the establishment of the new constitutional court, because at that time the political figures and party that negotiate the process to transition to democracy decide, okay, they want to create a new constitutional court that can protect the democracy itself. And at the time, especially the earlier time after the transition to democracy, there is an impression in the Indonesia that it seems the constitutional court was successfully eliminated this autocratic ideology and value in the Indonesian society. Some of their decisions give that impression because it seems promoting the liberal democratic values that previously by this to authoritarian regime, they give an impression that this ideology is enemy of the liberal democracy and other value like that, such as communist and Marxist. But with that impression from the court, it seems that Indonesia was successfully become a new liberal democracy in the Southeast Asia. But however, in recent years, especially since President Joko Widodo come to power, he's the current Indonesian president that come to power in 2014. I found that there are some tendency for Indonesia to come back to this authoritarian, to not come back to authoritarian, but there are a tendency for the authoritarian values in Indonesia to bring back and penetrate the public discourse in Indonesia. And what I found interesting is the constitutional court itself, that at first give the impression that they are the last bastion of the liberal democracy in Indonesia. There are also show that right now they are promoting the value of Pancasila, that sometimes it have many undemocratic elements. And this is some of the case when the constitutional court seems promoting this ideology. The first happened in the 2009. This is about blasphemy law case. Blasphemy law itself in Indonesia was infamously known as a tool or mechanism that usually was used by the Muslim majority groups in Indonesia to exclude religious minority. In this case, even with that many facts that show that this law was undemocratic and do not fit with the Indonesian goal to transition to democracy, but the constitutional court was upheld this law because, in their view, this law was need to protect the first principle of Pancasila, the belief in Almighty God. And I think in the decision itself, the court also argued that because the Pancasila emphasize the values such as harmony and unity, it's like my Thailand counterpart. So the court need to uphold this law, because if they eliminate this law, then the society will be disharmonized. That's the first attempt. But after that, in 2017, there also a case that this about the LGBT case. Actually, in this case, there are some petitions from some Indonesian conservative group. They want to criminalize LGBT in Indonesia, and what they petition has is not to. They want the court to give a broad interpretation to the provision in Indonesian Penal Code that criminalize sexual activity between adult and children. They want this provision in the Indonesian Penal Code was interpreted broadly, so it can also criminalize same-sex activities among adults. And honestly, in this case, the court reject the petitioner demand. However, they reject it not because they believe that the petitioner demand was inconstitutional or not, but because procedural value, because they believe if they accept this case, actually they will make a new norm. So it's outside their power. The Constitutional Court only believe that they power just to say that the law is constitutional or not make a new norm. However, in what in my opinion was a bit worrying is there are, from the 9 justices of the court, there are 4 dissenting judges in this case, and this judge believe that the court should play a more active role by accepting the petitioner demand and criminalizing same-sex activity among adults, because in their court view that the value of a belief in God, that was the first principle of Pancasila, mean that the Indonesian state was based from religious value. So since in the court opinion same-sex activity was prohibited by the most religion in Indonesia, so they believe that honestly the court should accept this petitioner demand. But what was most worrying for me is in 2017, this actually related to the current government interest to repress their oppositions. In this case, the current government, the Jokowi government, they create emergency legislations, which give his government the massive authority to ban any societal organization that, according to their view, was have a contradicting ideology with Pancasila. And this is a problem since Pancasila itself it's contain a very abstract principle. So it's very hard to say what value that actually contradict with Pancasila. So in this case, the court refused to annul this emergency legislations, even though the substance is very controversial, because and surprisingly, the court used the argument that usually was used by previous authoritarian regime in Indonesia by saying that the Pancasila is the legitimate basis for the state. So if you have an organization that have a competing view with Pancasila, it was a duty for the state to dissolve that organization, because for them, changing the Pancasila is equivalent to dissolving Indonesian state itself. So, and in my opinion, this decision was really, it's worrying, because it showed that the many authoritarian value in Indonesia that usually use ideology to repress political minority or political opponent was used by the court and it showed that in recent years that court seems use this authoritarian value and not promoting the liberal democratic value that actually was the reformer to the democracy once the court was worked. And based on that explanation from me and Rawin, we believe that in the country that lacking a liberal culture like Indonesia and Thailand, there are a possibility that court can be used to preserve a local ideology and custom. And the problem is the local ideology and custom in the society sometimes don't fit with the democracy. And since like what Rawin said, that actually when Hans Kelsen created the Constitutional Court, they have he have some value that want to promote with the court, like democracy and liberalism. But in the society like in Indonesia and Thailand, when the public itself have some local culture and ideology that do not fit with this with the value that the court should promote, the court can be trapped to become the guardian of this illiberal value. So we believe that to succeed in and to survive in this in this society that sometimes do not really respect the value of the liberal democracy, we believe that maybe sometimes the value of the ideology, the court also use sometimes this value and ideology to generate a space for itself, because it's hard to survive in the society with others. But the court must also aware that they should not be trapped by the undemocratic nature of this ideology. Maybe like using some of their argument that can promote democracy and liberalism in these two society. Rawin, maybe you want to add something?
No, thank you.
Okay, that's for us. Maybe we can explain more in the question and answer session. Thanks.
Thank you. Yes, definitely. I think we'll have lots of time for questions. So now if you want to transfer the host back to me, so if you go under participants, you should see it under hover over me and then more. Now, do we have our third presenter? Are you here? On the virtue of hermeneutical point of view, what can comparativists learn from legal theory? Do we have the presenter here? No. Okay. So then once you transfer it over to me, I guess I'll see if there's anyone in the waiting room. So maybe our next presenter's in the waiting room. So we'll see. Hang on. Are you seeing, Sachu, are you seeing how to transfer it back to me?
Sorry, how to transfer?
Yes, so if you go under participants.
Okay.
Yeah, and then hover over my name. And then under more, you should be able to make host, yeah.
Okay.
There we go, perfect. Okay, so I don't see anyone in the waiting room. So that's unfortunate. So I think we're gonna have to go with our third presenter today. Maybe they will suddenly pop in. But what a great set of papers. And it's also, yeah, really nice to, I like when you've got two people working on a paper, especially in the comparative context, it, really yields some really interesting work. So we can, I have some questions about that too and about Vanessa's, but I'll open up the floor first to anyone in the audience who might have some questions or comments. So feel free to jump in, and then I have some thoughts or questions that I'll eventually come up with as well once we've had the audience have a first go around. Oh, and also if you feel, I think you probably just unmute yourselves and speak if you like, but you can also feel free to write something in the chat, and we can do it that way too. Or maybe I'll talk a little bit while we're waiting for people to formulate their thoughts or what have you. So yeah, so thank you, Vanessa. I thought that was such a really great paper. You're right. I think that empirical data can yield so much information and kind of bring a lot to our work as comparativists and in law in general. So that's really, really nice to see. I know that that kind of work takes a lot of time, a lot of thoughtful work, and a lot of design need. So I thought it was interesting too when you mentioned near the end that kind of back and forth between different disciplines, and I think that added aspect. When we're dealing with comparative law, we have the balance that we're striking between the two different aspects or cases that we're looking at, but then also straddling disciplines and then dealing with the back and forth that we get with that. And I find that myself too. It's hard, the law and areas of work, right? Where how do you want to balance the law part, but then how also do you want to balance oh, hang on, I'm just going to interrupt myself here. I think we have our third presenter. So anyways, I'll keep talking about the papers, and then we'll hear from our third presenter. But yeah, so I think it's, it's hard to strike that balance between the law stuff that we're doing, then also the other discipline. And I find myself dealing with, sometimes there's pushback from the other discipline, in dealing with methods, and, are you doing them properly, but also are they dealing with what, we would as kind of the law, with our law hats, be doing, and hope that they would be doing on their end, and that back and forth. So my question is this, how have you been managing that? How have you been kind of negotiating that process with the law and the kind of the folks who are, maybe seated on the other side?
So I think that is the same struggle that I found when I was doing comparative law in the legal field. In Italy, many scholars say, don't listen to the sirens of comparison because you can get lost in abstraction and theories and methodology. And I find the same struggle here with other methods, especially statistical methods in my field. We have also, as you were saying, to balance these struggles, because the question and the final goal that we want is to highlight a question in law, not a question in anthropology or sociology, because those social sciences, they have other type of questions that can inform a question in law, but cannot substitute the legal question. So I think that it's fine to delve as much as we can in other methodologies, in other social sciences, but to keep in mind that the question that we want to answer is a question in law.
Thank you. Yeah, that's great. So I just wanted to know too, I'm so interested always in the kind of, you're dealing with the other disciplines and so on. So that our second paper, with two people working on it, I always am interested in, how did you start working together on this really interesting project, and how do you kind of negotiate that process? I just was curious with that, and then we'll go on to our third presenter. But if you guys want to, you can respond to that too, or you can wait till later. Go ahead if you want to jump in. Okay. Well, we can chat about it more later. So let's move on to our third presenter. So you were here, Gurkin, right?
Yes.
Okay, perfect. So what I'm going to do, and how we've been working this, is that I will transfer the host over to you. Well, first of all, do you have any slides that you'd like to share?
Yes, I have slides.
Okay, perfect. So I will transfer the host over to you, and then you can share your slides. And then once you're finished, you can transfer it back to me, because the host is the person who can let people into the Zoom room or what have you. So here, I'm just going to transfer this over to you. All right, there you go. So you should be able to share your slides, and then we've been doing about 20 minutes per paper. So if you have something around that time period, that's great.
Okay. Am I the first one that will present the paper? Because as far as I know, I am the third one, and I don't want to take anyone's place.
Oh no! So we started at, I guess, an hour ago. So yeah. So you're
okay.
Yeah, that's okay. I know time differences are
okay.
an adventure, but yeah. So you're actually the third one. So yes, you have the full 20 minutes. Don't worry.
Okay. Okay, I think you can see my slides right now. Okay, my name is Gürkan. I'm a PhD student at Santana School of Advanced Studies. Indeed, this is my first year as a PhD student. The title of my presentation is The Virtue of Hermeneutical Point of View and What Can Comparatists Can Learn from Legal Theory. Indeed, I'm just inspired from the article written by Kim-Lane Chappelle, Why Governance Checklists Do Not Work. In her article, she argues that private virtues may lead to public vices as opposed to Mandeville's fable of the beast. And for her, the devil is at the interactions, and we need new ways of seeing and new methodologies to challenge or to address the problems coming with abusive constitutionalism or populist governments. And I will try to ask the question of whether legal theory can prove useful for providing us new methodologies or new tools. Against this backdrop, I will try to address this more specific question: why the most prominent scholars in Turkey failed to see the fact that the 2010 constitutional amendment was indeed a constitutional capture, which drastically altered the composition of Constitutional Court from 11 members to 17 members. Also, there are other very important clauses. And for example, some of them argues that indeed this is a very positive attempt in the democratization of Turkey. Others have recourse to the reports of Venice Commission, and etc., etc. Some others, for example, Richard Talbot argues that indeed the change in the president of the Constitutional Court following the 2010 constitutional amendment was indeed a formal resistance against the unconstitutional constitutional amendment doctrine, because before the 2010 amendment in 2008, in its very infamous decision, the Turkish Constitutional Court applied unconstitutional constitutional amendment doctrine in a very, very wrong way. Anyway, but and these scholars describe a decision in 2016, and in this decision, the Turkish Constitutional Court did not apply the unconstitutional constitutional amendment doctrine, and they argue that this is indeed a formal resistance, but we have to ask and question: is it a formal resistance or indeed a court capture? Sorry. In addressing these two questions, I have two underlying aspirations. One of them is to strengthen the tie between comparative law and legal theory, first of all. Secondly, to establish firmer ties between methodology of comparative law and comparative constitutional law. In some sense, to transfer the takeaways of methodology of comparative law into the comparative constitutional law. The line of my argumentation will be as follows. I argue that both insiders and outsiders fail to comprehensively analyze the 2000 constitutional amendment, because they either adopt an extreme internal point of view, such as some Turkish scholars, or extreme external point of view, such as Venice Commission or some other scholars, regardless of their nationality, etc. But of course, being from Turkey is a huge advantage to understand what is going on and to approach from an internal point of view. But also there are some disadvantages of being a Turkish if you're trying to understand what is going on in Turkey, because you have to distance yourself from the culture also. Just as radical contextualism impedes to some extent objective evaluation, so too radical textualism hinders understanding the subjective nature of the observed phenomena. Therefore, I argue that the comparatist, to make a sound comparison, should embrace neither extreme external point of view nor extreme internal point of view, but expose a hermeneutical point of view between both of these extreme views. First of all, I will focus on some theoretical and methodological debates about internal, external, and hermeneutical point of view by drawing on some authors from legal theory, but also methodology of comparative law, also in general social sciences. In the second part of my presentation, I will focus on the Turkish context, what happened, and I will make a discursive analysis, and I will look at some arguments of the authors, and I will try to describe them, whether they approach from an internal point of view or external point of view or hermeneutical point of view. Why compare? Indeed, I think this is a very important question. I think we compare to understand each legal system on its own terms. Without understanding, it is almost impossible to compare. In some sense, comparison has so much to do with understanding. But then we have another question: how to understand? What kind of a methodology we should embrace to understand? And here, I think there's a very important phrase from George Simmel, and he argues that it is possible to understand Caesar without being Caesar. And I want to question whether it is possible or to understand Caesar without being Caesar. And here there's a two important paradigm. I think all you know about it, and or at least familiar in social sciences. On the one side, we have positivist scholars such as Marx, Durkheim, Comte, and on the other side, there are interpretivist scholars, especially neo-Kantians such as Dilthey, Hildebrand. And why positivists argue that reality is out there waiting for our own observation and description, humanitarian or interpretivist approach that there is nothing, social sciences is very different from natural sciences, and that's why we need some new tools such as Verstehen to understand what's going on. Also, Giddens argues that social sciences has a problem of double hermeneutics. They have to grapple with the problem of double hermeneutics because we try to understand the meaning that is already given by some other people, because there's a problem of pre-interpretive phase in social sciences. That's why the mere observation is not enough. Here, I think Weber try to reach a consensus between these two radical stances. On the one side, there are natural sciences, and on the other side, there are radical social sciences. These radical social sciences, we can call them call their thesis as strong Verstehen thesis, the one that is supported by Hildebrand, Dilthey, and they all argue that understanding Caesar is not possible without being Caesar, because to understand you need to be part of this culture and this language, this society, because understanding has so much to do with history, and this language, law, culture, all these kind of norms is the outcome of historical process, etc., etc. And Weber here tried to reach a consensus. On the one side, he tried to preserve the scientificity of natural sciences, objectivity of social sciences. On the other side, Weber tried to protect this sophisticated understanding of Verstehen, of social sciences. He tried to preserve this insight. And I think hermeneutical point of view follows the path of Weber here, and we will later see this distinction. But they try to also preserve a middle way between extreme two positions. We also see in comparative methodology of comparative law this kind of distinction. On the one side, there are functionalists or textualists such as Zweig and Kurtz. On the other side, we have contextualists or extreme radicalists such as Pierre Legrand. I just skipped this part. Recently, we also see some scholars argues that we need to establish a firmer connection between legal theory and comparative law, and they also take some tools and transfer them into the comparative law. For example, Ewald argues that we need to approach law from inside. It is not enough to describe law outside, etc. Walke, I think, with her article beginning from 2006 up until these days, she also argues that we need to approach law from inside. You can just see some phrases here. Walke argues that law can only be fully understood from within, from the perspective of the arguments makers. Law is not just a mechanical behavior, but in fact an ethos. That's why it is not possible to understand law by merely observing from a distance. And I think Valke also followed the path of Weber, and she also argues that no need to be a Caesar to understand Caesar. At least it is my argument. I just passed these parts. When it comes to jurisprudence and legal theory, we also see a very different, very similar distinction between internal and external point of view. Hart, in his concept of law in 1961, criticized Austin because Austin argues that law is the order of or command of sovereign, and people just obey the law as if they are robots, and because law forces people to be obeyed, etc. But Hart argues that no, you cannot just describe law as such. Law, you need to understand law, you need some different methodologies, you need to approach law from an internal point of view, because people obey law not just because they are forced, but because they create their own normativity. They think that law provides them a reason to comply with the rules. Later on, McCormick argues that indeed in Hart's concept of law, Hart mentioned two different types of internal point of view. One of them is extreme internal point of view. The other one is normal internal point of view. In extreme internal point of view, it is the point of view of people that is obeying the law, complying with the law, taking the rules of law as a guide to their own behaviors. On the other side, there are other kind of peoples, legal theorists or social scientists, approaching law from inside, but they are not trying to. They are not looking at law as a guide for their own behaviors. They are trying to understand what law is. That's why, when it comes to extreme internal point of view, in this point of view, people look at the law from a pragmatic, practical point of view. They are asking the question of what should I do, and look at the law. Okay, I have to behave like that. But when it comes to social scientists, they are asking some theoretical questions. What is law? And they are just trying to understand what law is. And this is why a hermeneutical point of view is a middle way in it between internal and external point of view, between the mere rule applier, the mere people that obeying the law, and between extreme external one, mere natural scientist observing the phenomenon of law. And I think this is the point of view, hermeneutical point of view, is the point of view indeed a comparatist should embrace to understand what law is when in its analysis in law, in comparison. Anyway, why hermeneutical point of view? I think, first of all, it shows respect for the authenticity of people's thinkings, doings, ideas. It shows their dignity, human dignity. It shows respect to their human dignity, their authenticity, their autonomy. We can just establish a connection here with even Kant and even this deontological tradition, because these people just try to build their own understanding and social faiths. I'm just passing here. Okay, we just passed here to the second part. Here, I will just briefly explain the background of Turkish Constitutional Court and the crisis in 2010 and the 2010 Constitutional Amendment. And by looking at the discourses, I will try to draw a distinction between insiders, outsiders, and the one that embrace hermeneutical point of view. Indeed, the Turkish Constitutional Court is one of the most activist courts in the world. The first court deploying the unconstitutional constitutional amendment doctrine in Europe, closed 18 political parties in a decade during 1990s. The perfect example of a militant democratic court. However, in 2016, in parliamentary immunity case, didn't follow its precedent and did not apply unconstitutional constitutional amendment doctrine. Also goes against her precedent about emergency decrees, following the failed coup attempt. And we can just describe this, I think, as a signifier of the captured court. Also, Dixon and Landau in their article in 2019 abusive judicial review argues that after a constitutional amendment, if the court changed her precedent radically without any justification, we can just say that, okay, this a court is captured indeed. When it comes to 2010 constitutional amendment, there are 26 articles in the amendment. 9 of them were about judiciary, 7 of them about fundamental rights. The crux of this amendment is indeed about changing the judiciary. The composition of the Constitutional Court changed drastically from 11 to 17 judges. Also, the composition of the Supreme Council of Prosecutors and Judges changed. Indeed, this constitutional amendment was the outcome of a political backlash, because in 2007 and 8, there were three very important decisions of Turkish Constitutional Court. All of them is really hard to justify from a legal point of view, even from the point of view of political legitimacy, etc. Court just forced its own boundaries during this decision, and we can just think 2010 constitutional amendment as a political backlash. This also may explain that indeed this amendment was a court capture. When it comes to the different point of views, first of all, I argue that during the 2000s, there is a hegemony of hegemonic preservation thesis in Turkey. As you may all know, there is a hegemonic preservation thesis of Hirsch. Hirsch argues that constitutional courts indeed protects the interest of hegemonic elites rather than minority or protection of fundamental rights, etc. And lots of authors just argue that Turkish Constitutional Court is a perfect example of Hirsch's hegemonic preservation thesis. And that's why there is an ongoing discourse in Turkey during 2000s till 2010 to change or to democratize the Turkish Constitutional Court. You may just see the name of the articles here. They argue that the court was conceived as an instrument that will protect the fundamental values and interests of state elites. The court seen as a major obstacle against democratization of Turkey. For example, Bali, Aslı Bali, in her analysis of the 2010 constitutional amendment, argued that indeed this is an attempt to unpack already packed court by democratizing judiciary. The amendment should have been greeted. They all just argued that it reformed some of the most illiberal provisions, etc., etc. I'm just passing these parts. For example, again, Aslı Bali argues that the most significant lesson to be drawn from this experience is the importance of extending mechanism of democratic accountability to the courts in areas of judicial governance, like appointments and promotions, especially during transitions. A doctrine of separation of powers that includes the institutional prerequisites for producing a judiciary reflective of the underlying society is particularly important. Of course, I don't agree with this phrase, because Bali tried to align judiciary with the society, but indeed, Constitutional Court has lots of different functions, and democracy is one of them. Is not one of them, especially because we can just expect parliamentary or lots of other branches to be democratic, but when it comes to Constitutional Court, it's more than ever protects constitution, separation of powers, maybe constitutional courts, maybe the rights of minority, but it has nothing to do with indeed the understanding of democracy proposed by Bali. Also, I think these Bali, Özbudur, and other Turkish scholars embrace an internal point of view. They immersed so much in their own culture. That's why they could not evaluate what's going on in Turkey. But also, there are some scholars or Venice Commission, they just embrace external point of view, and they argue that this is a positive step on the democratization of Turkey, because they, for example, in 2010 constitutional amendment, there's a clause for individual people just complain against Constitutional Court, and they just argue that indeed it's a positive step for the protection of fundamental rights and could be used as a positive argument. Also, there are some scholars arguing in favor of 2010 Constitutional Amendment. For example, as I said, Richard Albert, Tarık Olcay, and Nakashidze, in their argument for modest resistance to unconstitutional constitutional amendments, argue that the Turkish Constitutional Amendment, Turkish Constitutional Court, in its 2016 decision, changed its precedent, and indeed this is a formalist resistance. But I think it is indeed a court capture. They are just looking at what is going on in law in books, but what about law in action or law's interaction with politics? And that's why they are not embracing an internal point of view here. When it comes to the virtue of hermeneutical point of view, for example, Varol argues that although majority of the amendments are a cause for celebration, 2 amendments raise grave concerns. These 2 amendments take aim at Turkey's once independent judiciary. I think this is very important, because when we just look at to the fact that the composition of the courts just increased from 11 to 17, okay, we can just think that this may be an attempt to capture the court. Okay, yes, this is true. But Varol also says that when we look at the political dimension of this change, before amendment, 6 of the judges to the Constitutional Court was assigned or appointed by counter-majoritarian institutions, such as high courts or judiciary. And 5 other judges was assigned by majoritarian institutions. But after the amendment, this balance changed at the expense of counter-majoritarian institutions, and it changed from 6 to 11. That's why all the 6 members just put these government-friendly institutions, and that's why indeed this is absolutely a court capture. And if we just look at law in actions and behind the law in books, I think it is obvious that, or if we embrace a hermeneutical point of view, this is indeed a court capture. Also, Andrew Arato perfectly explains at that time in 2010, he argues that given the evolving nature of Turkish politics, such a renewed role for the court was not the appearance of a juristocracy, but the establishment at least one check and balance in an increasingly monolithic system. This is what Arato argues against hegemonic preservation thesis. Those Democrats are Balı or Özbudun, who in that context attacked the court for historically understandable reasons, because Turkish Constitutional Court was really activist, okay, were nevertheless fighting the battle of yesterday, failing to see the very possible, if not inevitable, dangers of tomorrow. And today we are at tomorrow, and it is obvious in what kind of a situation we are in right now. I'm just looking. Also, Arato, even in 2010, before Chappelle's groundbreaking article argues that one could indeed put together quite an authoritarian system by choosing some particular mix of regulations from various illiberal democratic states. Indeed, this is what Kimberly Chappelle explained in her article. Why governance checklists do not work, because we cannot just see the interactions, and that's why we need a hermeneutical point of view. Thank you for listening to me. This is the end of my presentation. I'm just...
Thanks very much for that paper. I'm happy that you were able to join us in the end. That was a nice third paper to round out what we've heard today. So just in terms of logistics, if you can pass the host back to me so that I can see if
yes, I will try to do that.
Okay. Do you know how to, so if you go into participants and then hover over me, there should be a little sign that pops up saying more, and then you can remake.
Yes, I just stopped share. Okay. Okay, I managed to do that.
Anyways, as we're doing this, then does anyone have any questions or comments on any of our papers that we've heard today. If you want to just, there aren't too many of us, so if you want to just go ahead and talk, I don't think there's a need to raise your hand or what have you. Or of course, different participants, you can talk to each other too about your papers. I think there's some interesting discussions that could be had.
Hi, I just wanted to congratulate all of you. It's been really interesting to hear different perspectives from such different countries. I have so many questions. I haven't seen Mexico as a country compared with the expositions from this week, no? So that's, I have so much homework to take into consideration your points of view. Congratulate you again. I'll try to be in touch with you. Thank you.
Any other?
Yeah, I don't know if you can hear me.
Yeah.
Okay, so I have a question for Gurkan regarding his exposition. So you were talking about law in books and also law in action as a way to understand comparative law. Do you think that there are also non-legal answers to societal needs?
Of course, of course. Indeed, I'm just studying legal theory, and we are in Turkey maybe, but we are just generally look at law in books and positive law, how it's going on, and what kind of a decision a court gives, etc., etc. But as you said, there may be, of course, some societal and political answer to this kind of problems. Indeed, of course, it is obvious Turkey is not a very democratic country, and there are lots of reasons of that, because we just experienced a late modernization process beginning from 1920s, etc. And that's why it is in some sense very hard for this kind of late developed countries to catch other early developed countries. And lots of, I think, scholars, political scientists, social scientists could make lots of explanations regarding this. But at least for my argument in my presentation is to have a different kind of approach to the court, because there are lots of scholars making comparison between different kind of constitutions or constitutional courts, as if without even caring about methodology, without even thinking about methodology. Also, it may be a way, because, for example, functionalism, etc., and this is the default rule. If you just compare it, okay, this is a way, and this is a way of gathering data, but sometimes we need to be a little more critical to comparison, especially if you are experiencing this kind of radical tradition. Because sometimes this kind of, for example, Ergun Özbudur is one of the most important scholars in Turkey and could not grasp what's going on in Turkey. And this may give rise to huge and very, very bad consequences. Yeah, I don't want to blame anyone, but anyway, it is really important in some sense. That's all. Thank you very much for your question.
So I will have a follow-up question to your comment. So would you place yourself, you said that you place yourself within functionalism in comparative law? As a functionalist?
Of course not. I believe that we need to approach law from inside with its political context, etc. But if you want to compare some different legal systems, you need some objectivity as well. For example, just think about Zimmel argument. It is impossible. For example, someone argues that it is impossible to understand Caesar without being Caesar, because everybody living its own culture. If you just make a, for example, participatory research, if you don't participate in research, for example, 3, 4, 5 years, and immerse in this culture and to feel what is being like, for example, as a soldier, and you want to try to understand what is being a soldier, and you are just training as a soldier for 5 or 6 years, and then later you are writing something. Okay, you understand Caesar by practicing as a Caesar, but comparative law is not like that. You have to at least distance yourself from being a mere soldier, because you need to compare different kind of soldiers. And that's why you need to compare the law in France, Italy, etc., etc. And that's why you need some grounds to compare. Also, I think it is not only about between different legal cultures, or between. It is not only about territorial. It is also about there are also disciplinary boundaries, because there is boundary between law and economy. If you just apply the tools of economy to law, I think you may have some problems. You have to be more careful while at least applying this. You need to embrace at least a hermeneutical point of view, the point of view of Weber, and maybe this path followed by McCormick and maybe Walke in the latest years. At least this is what I thought.
So, since you're talking about this objective standard, how can we compare and maintain at the same time the difference, even in comparison? Because if we are talking about only objectivity, then we're losing the part that comparative law wants to merge, right? The cultural part.
Mm-hmm. Yes, you are right. This is the main challenge, to preserve some scientific objectivity and to protect the particularity of these every different culture. This is the main challenge, and I think it is impossible to give a one right answer to this question. It will change in accordance with every situation and every context. We can just give some procedural answers, maybe. For example, hermeneutical point of view is a procedural answer. It is not a substantive answer. I just say that you have to approach like that. But this approach will change in accordance with lots of different situations.
Thank you.
Yeah, this is thank you very much for your question.
Any other questions amongst our participants and audience? Oh, one thing I was curious about for the second paper we had from Roween and Satrio, at the very end you mentioned this this idea, the role of assumptions about governments that just don't reflect local culture. And so I wanted to know if you could kind of expand a little bit on what you thought, working together in this project, that might be some steps forward, or kind of where you think that how that could be remedied.
Okay, so I can go first. Well, I think that the Thai and Indonesian experiences reflect how how different political forces struggle against each other, and I mean, if you read the news about Thailand, even today, you can see that that without a political struggle, democracy cannot take place. Because as in our country, as the experiences of our country have shown, the institution meant to be the guardian of liberal democracy itself, such as the constitutional court, has even been politicized by the elites. So I mean, our countries show that we cannot trust the government, only the government. We cannot just believe that only the government can put forward the process of democratization in our countries. Only the power of the people itself, can realize such a thing, and it's just about struggle, yeah. Have any further comments, Sartrio?
Maybe not for this time.
Thank you. Any other thoughts or questions for our panelists? I really liked how all of you, really went into not just, presenting the paper, the work, but also a lot of the, why the work you're doing is important and how. And so, kind of how that speaks to methodology. So that was great. Anyways, I think, do we have any other final questions? Wait. So what I'm going to do is I think I'll end that here so that this virtual room is going to be used for the next panel. So we'll end it here, and then everyone can have a little break before we head to the next session. So thank you, everyone. Thank you for 3 really very interesting papers, and it's really great to hear all of them. And of course, if you have any further thoughts for each other or questions, as everyone always says, feel free to reach out and ask each other over the rest of the day in other rooms or via email or what have you. So thank you, everyone, and I will probably see you later on today.
Thanks very much.
Thank you.
Thank you.
Thank you to all the participants.
Thank you.